The Senate Judiciary Committee hearing room was packed when Representative Jasmine Crockett approached the microphone carrying a thin blue folder that would upend everything. Supreme Court Justice Brett Kavanaugh shifted uncomfortably in his seat at the witness table, glancing toward the exit. "Justice Kavanaugh," Crockett began, her voice steady and clear, "I have documentation showing that your wife's consulting firm, Ashley Kavanaugh, LLC, received $1.8 million from 3 major corporations with active cases pending before the Supreme Court." The room fell silent as Crockett opened the folder and placed several documents on the display screen. "These financial records show payments from Multicorp Industries, Titan Pharmaceuticals, and Westland Energy, all made while their cases were on the court's docket." Kavanaugh's face visibly paled as he glanced desperately at his legal counsel seated beside him. "Most troubling," Crockett continued, sliding another document onto the screen, "is this email from Ashley Kavanaugh, LLC to Multicorp's chief legal officer, dated 2 weeks before you cast the deciding vote in their favor, stating, 'The consulting agreement should remain confidential as it would create obvious complications if disclosed.'" Gasps erupted from the gallery as Kavanaugh abruptly stood, knocking over his water glass. This is outrageous," he stammered, his voice shaking. "I need to consult with counsel before continuing." Without waiting for the chairman's permission, Kavanaugh turned and strode quickly toward the exit door, followed by his stunned legal team as cameras flashed frantically. What happened in the next few minutes would forever change the public's understanding of judicial ethics and transform the Supreme Court's approach to conflicts of interest in ways no one could have predicted. Before we dive into the explosive evidence that Representative Crockett revealed next and the unprecedented aftermath, don't forget to like this video and subscribe to our channel for more exclusive coverage of the pivotal moments reshaping America's democratic institutions. To understand why this confrontation sent shockwaves through Washington's legal and political establishments, we need to examine the backgrounds of these two formidable legal minds and the context that brought them into this historic collision. Jasmine Crockett had established herself as one of the most methodical members of Congress since her election in 2022. Before entering politics, she had built a respected career as a civil rights attorney in Texas, where she developed a reputation for meticulous case preparation and an unwavering commitment to procedural integrity. Crockett approaches congressional oversight the same way she approached the courtroom, explained her former law partner in a Texas Tribune profile. She builds cases brick by brick with documentation for every assertion. She doesn't make claims she can't substantiate, which makes her particularly effective when she does speak up. This approach had made Crockett an unexpected force on the House Judiciary Committee, where colleagues had learned that her quiet preparation often yielded more substantive results than theatrical questioning. Unlike representatives who used hearings primarily for sound bites, Crockett became known for substantive lines of inquiry that frequently yielded newsworthy revelations. "She doesn't ask questions to hear herself talk," noted a senior congressional staffer. "She asks questions because she already knows the answers and wants them on the public record." Brett Kavanaugh had taken a very different path to this confrontation. Confirmed to the Supreme Court in 2018 after one of the most contentious nomination processes in American history, Kavanaugh had spent his years on the bench attempting to rehabilitate his public image through careful judicial temperament and a lower public profile than he had displayed during his confirmation hearings. In public statements, Kavanaugh had repeatedly emphasized judicial ethics and the importance of maintaining public confidence in the court's impartiality. In a 2022 speech at Notre Dame Law School, he had specifically addressed concerns about conflicts of interest, stating, "Judges must not only be impartial, but must be seen to be impartial. The appearance of impropriety can be as damaging to public confidence as impropriety itself." The path to this confrontation began 7 months earlier, when a financial reporter for ProPublica noticed an unusual pattern while investigating corporate influence in Washington. Several major corporations with cases pending before the Supreme Court had made substantial payments to a consulting firm called Ashley Kavanaugh, LLC. This initial finding might have generated only modest interest except for a crucial detail. The LLC had never been disclosed on Justice Kavanaugh's mandatory financial disclosure forms, despite ethics rules requiring justices to report their spouse's income sources. Working quietly with researchers and document specialists, Crockett's office had spent months following the money trail, obtaining corporate payment records, email communications, and LLC registration documents that established a troubling pattern. According to their investigation, Ashley Kavanaugh's consulting work had expanded dramatically after her husband joined the Supreme Court, with her client list increasingly populated by corporations with interests before the court. Most concerning was the timing of certain payments, which coincided closely with the court's consideration of cases involving these same corporations. The payments themselves weren't necessarily improper. Ashley Kavanaugh had legitimate professional credentials. But the failure to disclose these relationships on mandatory ethics forms raised serious questions about transparency and potential conflicts of interest. "We weren't looking to create a gotcha moment," a Crockett staffer later explained. "We were investigating a genuine ethics concern about undisclosed financial relationships that could affect public confidence in judicial impartiality." The hearing had been convened as part of a broader examination of judicial ethics reforms following several high-profile controversies involving Supreme Court justices. Kavanaugh had agreed to appear voluntarily, likely expecting questions about general ethics principles rather than specific undisclosed financial connections. What he couldn't have known was that Crockett's team had obtained internal emails from a whistleblower at one of the corporations involved, communications that suggested the consulting relationship was deliberately structured to avoid disclosure requirements. The stage was set for a confrontation that would test not just Kavanaugh's financial disclosures, but the Supreme Court's entire approach to ethical self-governance and the boundaries between a justice's household finances and their judicial obligations. As Kavanaugh exited the hearing room with cameras capturing his hasty departure, committee members from both parties sat in stunned silence, recognizing they were witnessing an unprecedented moment in Supreme Court oversight. Do you think Supreme Court justices should have stricter financial disclosure requirements than they currently do? Share your thoughts in the comments below. The hearing room erupted into chaos as Justice Kavanaugh disappeared through the side door. The committee chairman banged his gavel repeatedly, struggling to restore order while staff members huddled in urgent consultation. "The committee will come to order," the chairman finally announced. "We will take a 15-minute recess while we determine how to proceed." As senators filed out, Crockett remained at her seat, calmly organizing her documents. Unlike the surprised expressions of many colleagues, her demeanor suggested this outcome wasn't entirely unexpected. She had prepared not just for questioning Kavanaugh, but for the possibility that the evidence might provoke exactly this reaction. When the committee reconvened, the chairman addressed the situation. "Justice Kavanaugh's counsel has informed us that he needs time to review the documents presented by Representative Crockett before responding to questions about them. He has requested a continuance of today's hearing." Rather than simply granting the request, the chairman turned to Crockett. "Before ruling on this request, I'd like Representative Crockett to provide the committee with an overview of these documents and how they were obtained." This unexpected opportunity allowed Crockett to present her evidence methodically, without interruption or defensive responses from Kavanaugh, essentially giving her case against the record with the justice absent. "Thank you, Mr. Chairman," Crockett began, her voice measured and precise. "The documents I've presented come from multiple sources, all legally obtained." She displayed the first document on the committee room screens. This is the Delaware LLC registration for Ashley Kavanaugh LLC, established 3 months after Justice Kavanaugh's confirmation to the Supreme Court. The registration lists Mrs. Kavanaugh as the sole member and describes the business purpose as Strategic Communications Consulting. Crockett moved to the next document. These are quarterly payment records from Multicorp Industries to Ashley Kavanaugh LLC, showing payments totaling $685,000 between January 2020 and March 2023. During this same period, Multicorp had 3 separate cases before the Supreme Court, including Multicorp v. Department of Labor, which Justice Kavanaugh joined the majority opinion favoring Multicorp. she continued systematically, displaying similar payment records from Titan Pharmaceuticals and Westland Energy, each showing substantial consulting fees coinciding with periods when these corporations had cases pending before the court. The combined payments exceeded $1.8 million over 3 years. These financial relationships would be concerning but perhaps explicable if they had been properly disclosed on Justice Kavanaugh's annual financial disclosure forms, Crockett noted, displaying the justice's official disclosures. However, as you can see, there is no mention of Ashley Kavanaugh, LLC, or any of these client relationships on any of his filings from 2019 through 2023. What made Crockett's presentation particularly powerful was her refusal to engage in speculation or partisan framing. Each statement was directly tied to specific documentation displayed on screen, creating a factual record that couldn't easily be dismissed as political theater. The Ethics in Government Act requires justices to disclose the source of any spousal income exceeding $1,000, she explained. Based on these records, Justice Kavanaugh appears to have omitted over $1.8 million in spousal income from corporations with direct interests in cases before him. Then came the most damaging evidence: internal emails obtained through a whistleblower at Multicorp Industries. Crockett displayed an exchange between Ashley Kavanaugh and Multicorp's chief legal officer regarding the structuring of their consulting agreement. The most problematic email read, "We'll structure the agreement through the LLC rather than directly with you personally. This provides an additional layer of separation for disclosure purposes. Justice Kavanaugh only needs to report your direct income sources, not clients of your business entity." A follow-up email stated, "The consulting agreement should remain confidential as it would create obvious complications if disclosed." These communications suggested not just an oversight, but a deliberate strategy to circumvent disclosure requirements, a much more serious ethical concern than simple negligence or misunderstanding of the rules. As Crockett methodically presented each piece of evidence, the atmosphere in the hearing room transformed. What some senators had initially viewed as a potential partisan attack now appeared to be a substantiated case of significant disclosure violations that raised legitimate questions about judicial impartiality. "Finally, Mr. Chairman," Crockett said, displaying a Supreme Court docket, "I want to draw the committee's attention to the timing of certain payments and judicial actions. This document shows that Multicorp's final payment of $125,000 to Ashley Kavanaugh, LLC, was processed on October 12, 2022. 8 days later, Justice Kavanaugh cast the deciding vote in Multicorp v. Department of Labor, writing a concurring opinion that specifically addressed the regulatory issue central to Multicorp's business model." She continued, "Similarly, a $95,000 payment from Titan Pharmaceuticals was made 3 weeks before Justice Kavanaugh joined the majority in declining to hear a case that would have allowed generic competition for Titan's flagship product." Throughout her presentation, Crockett maintained a professional tone focused on the ethical standards applicable to all federal judges rather than personal attacks on Kavanaugh. This approach made it difficult for even the justice's supporters on the committee to dismiss the concerns as merely partisan. "Mr. Chairman," she concluded, "these documents raise serious questions about compliance with basic disclosure requirements designed to maintain public confidence in judicial impartiality. The Ethics in Government Act doesn't prohibit spouses of justices from pursuing professional careers, but it does require transparent disclosure of financial relationships that could create actual or apparent conflicts of interest." The impact of Crockett's methodical presentation was immediately apparent in the questions and comments from committee members of both parties. Republican senators who had arrived prepared to defend Kavanaugh now asked more measured questions about the documentation and the applicable disclosure rules. Representative Crockett asked a senior Republican member, "Can you clarify how these documents were obtained? I want to ensure we're proceeding with properly sourced information." "Certainly, Senator," she replied. "The LLC registration and Justice Kavanaugh's financial disclosures are public records. The payment information came from corporate SEC filings and shareholder reports. The emails were provided by a whistleblower who had legal access to them in the course of their employment and who was concerned about potential ethics violations. Another Republican senator followed up. Is there any indication that Justice Kavanaugh was personally aware of these specific clients or the advice his wife gave regarding disclosure strategies? The documents don't explicitly confirm his personal knowledge, Crockett acknowledged. However, ethics rules place the responsibility for accurate and complete financial disclosures on the justice regardless of whether he was personally involved in structuring the arrangements. The standard is what he should have known and disclosed, not just what he personally negotiated. This measured response further strengthened Crockett's credibility. By acknowledging the limitations of her evidence rather than overreaching, she demonstrated that her concern was institutional integrity rather than partisan advantage. Democratic members focused their questions on the implications for pending cases and the adequacy of the court's existing ethics framework. Representative Crockett asked a Democratic senator, based on your research, how many current cases before the Supreme Court involve companies that have financial relationships with Ashley Kavanaugh, LLC? Our review identified 4 cases currently on the docket involving either the corporations themselves or their subsidiaries or industry associations where these corporations hold leadership positions, she replied, displaying a document that mapped these connections. As the questioning continued, the committee gradually shifted from examining the specific allegations against Kavanaugh to considering the broader implications for judicial ethics. This evolution reflected the effectiveness of Crockett's approach. By focusing on documented facts rather than partisan framing, she had created space for a more substantive conversation about institutional reforms. Mr. Chairman, said a moderate Republican senator near the session's end, regardless of how we proceed with Justice Kavanaugh's testimony, I believe these documents raise important questions about our disclosure requirements and whether the current system adequately protects against conflicts of interest. I would suggest we consider a bipartisan working group to examine potential reforms. This suggestion, coming from a Republican rather than a Democrat, marked a significant victory for Crockett's methodical approach. By presenting evidence in a way that emphasized institutional integrity rather than partisan advantage, she had created an opening for meaningful reform that transcended typical political divisions. As the hearing adjourned, the chairman announced that Justice Kavanaugh's testimony would be rescheduled for the following week, giving him time to review the documents and prepare responses. This delay, rather than simply canceling the appearance altogether, suggested that even Kavanaugh's allies on the committee recognized that the questions raised required substantive answers. For observers of the judicial ethics debate, Crockett's methodical presentation represented something rare in contemporary oversight hearings, a focus on documented facts and institutional principles rather than partisan point scoring. As the senators filed out, the evidence remained displayed on the committee room screens, a visual reminder of questions that could no longer be easily dismissed. The impact of Crockett's methodical presentation reverberated far beyond the committee room. Within hours, major news organizations had obtained copies of her documentation and began publishing detailed analyses of the financial connections she had exposed. Supreme Court ethics crisis deepens. Kavanaugh's wife's undisclosed corporate ties revealed, read the Washington Post's headline. The Wall Street Journal, typically more sympathetic to conservative jurists, ran with the more measured but still damaging. Kavanaugh faces questions over spousal income disclosures. Legal ethics experts across the political spectrum acknowledge the significance of the revelations. The issue here isn't partisan politics but basic transparency, noted conservative legal scholar Jonathan Adler. The disclosure requirements exist precisely to ensure that the public can assess potential conflicts. If these payments weren't disclosed, that's a legitimate concern regardless of one's judicial philosophy. The Supreme Court initially maintained its customary silence on matters involving individual justices. However, by the following morning, the unprecedented nature of the situation forced a response. Chief Justice John Roberts issued a brief statement acknowledging the seriousness of the allegations and announcing that the court would address them in accordance with its established procedures for ethical matters. This carefully worded statement represented a significant departure from the court's typical approach of leaving individual justices to handle their own ethical questions. The fact that Roberts had felt compelled to comment publicly suggested the institutional gravity of the situation. For Justice Kavanaugh, the days following Crockett's presentation brought mounting pressure. Additional reporting revealed that Ashley Kavanaugh LLC had more corporate clients than initially identified, several with interests in matters before the court. Legal analysts pointed out that the consulting relationships, while not necessarily improper in themselves, should have been disclosed under existing ethics rules to allow for appropriate recusal considerations. 3 days after the hearing, in a move that stunned legal observers, Justice Kavanaugh issued a personal statement acknowledging significant oversights in his financial disclosures. While I believe the LLC structure eliminated the disclosure requirement, I now recognize this interpretation was incorrect, he wrote. I take full responsibility for these omissions and am working with the Judicial Conference to file amended disclosures for all relevant years. This acknowledgment represented a significant vindication of Crockett's approach. Rather than dismissing her evidence or attacking her motivations, Kavanaugh had essentially conceded the central factual claim that required disclosures had not been made. More significantly, Kavanaugh announced that he would recuse himself from all pending and future cases involving companies with financial connections to his wife's consulting business. To maintain public confidence in the court's impartiality, I will step aside from these matters until appropriate disclosure and recusal procedures can be established, he stated. This decision, affecting nearly a dozen cases on the court's docket, represented an extraordinary response to congressional oversight. Supreme Court justices had historically resisted external pressure regarding recusal decisions, maintaining that such matters were entirely within their individual discretion. Kavanaugh's announcement signaled a potential shift in this long-standing position. For Crockett personally, the aftermath brought professional recognition rather than partisan attacks. Legal commentators from across the political spectrum praised her methodical, evidence-based approach to oversight. What made Representative Crockett's presentation so effective wasn't theatrical questioning or political grandstanding, observed former federal judge J. Michael Luddig, a respected conservative jurist. It was her focus on documented facts and applicable standards rather than partisan framing. That approach makes it much harder to dismiss legitimate ethical concerns as merely political attacks. This assessment was echoed by judicial ethics experts who had long advocated for stronger disclosure requirements. Crockett demonstrated how congressional oversight is supposed to work, noted NYU law professor Stephen Gillers. She built a factual case, presented it without unnecessary partisan framing, and allowed the evidence to speak for itself. That's accountability in its most effective form. Perhaps most significantly, the revelations catalyzed movement on judicial ethics reforms that had previously stalled in Congress. 1 week after the hearing, a bipartisan group of senators announced a framework for legislation that would create clearer disclosure requirements for justices' household income and establish an independent review process for Supreme Court ethics issues. The Crockett-Kavanaugh hearing demonstrated that our current system relies too heavily on individual justices' interpretations of their ethical obligations, said the Republican co-sponsor of the proposed legislation. We need clearer standards and better accountability mechanisms to maintain public confidence in the court as an institution. This bipartisan support reflected Crockett's success in framing judicial ethics as an institutional concern rather than a partisan weapon. By focusing on documented disclosure violations rather than attacking Kavanaugh's judicial philosophy, she had created political space for reforms that might otherwise have been dismissed as partisan attacks on conservative justices. 2 weeks after the hearing, the Supreme Court itself announced the formation of a working group to develop formal ethics guidelines specifically addressing spousal income and business relationships. This unprecedented step, the court had long resisted adopting binding ethics rules, suggested that Crockett's revelations had prompted serious institutional reflection. The court recognizes that public confidence is essential to our constitutional role. Chief Justice Roberts stated in announcing the working group. While justices have always held themselves to high ethical standards, recent events suggest that more formal and transparent guidelines may be necessary in certain areas. Legal observers recognize this statement as a significant shift in the court's traditional position that it should be exempt from the ethics rules governing lower court judges. The fact that Roberts had acknowledged the need for more formal and transparent guidelines represented a remarkable institutional response to congressional oversight. For the broader public, the Crockett-Kavanaugh confrontation offered something increasingly rare in political discourse: evidence that systems of accountability could still function effectively when approached with seriousness and substantive focus. Rather than dismissing the evidence along partisan lines, key institutional actors had acknowledged legitimate concerns and begun working toward meaningful reforms. As one constitutional scholar observed in an Atlantic analysis, what Representative Crockett accomplished wasn't just exposing one justice's disclosure oversights. She reminded us that accountability requires neither partisan attack nor institutional defensiveness, but a shared commitment to transparent governance. That's a lesson our divided democracy desperately needs. 6 months after the historic hearing, its impact continued to reshape the relationship between the Supreme Court and the public it serves, producing institutional changes that few had thought possible before Crockett's methodical presentation of evidence. The most immediate result was a comprehensive reform of the Supreme Court's approach to financial disclosures. Under guidelines developed by the court's Ethics Working Group and implemented by Chief Justice Roberts, justices now filed more detailed annual reports that explicitly included spousal income from all sources, including business entities and LLCs. These enhanced disclosure requirements reflect the court's commitment to transparency and public confidence, Roberts stated in announcing the new procedures. While respecting the legitimate privacy and security interests of justices and their families, we recognize that meaningful disclosure is essential to maintaining trust in the judicial process. For Justice Kavanaugh personally, the aftermath brought both accountability and an opportunity for institutional repair. Following his amended disclosures, which revealed even more corporate connections than Crockett had initially identified, he recused himself from 17 cases on the court's docket, significantly affecting the court's deliberations on several major corporate liability and regulatory issues. In a move that surprised many observers, Kavanaugh also accepted an invitation to speak at a judicial ethics conference at Georgetown Law School, where he acknowledged that the experience had prompted personal reflection. Throughout my judicial career, I have focused on interpreting the law according to established principles, he told the audience of law students and professors. But recent events have reminded me that the judiciary's authority rests as much on public confidence as on legal reasoning. Transparency isn't just a procedural requirement but an essential component of legitimacy. This statement, from a justice who had previously defended limited disclosures, reflected the profound impact of Crockett's evidence-based approach. By focusing on documented facts rather than partisan framing, she had created a situation where even those who might disagree with her politics could recognize the legitimacy of her concerns. Beyond Kavanaugh himself, the hearing catalyzed broader reforms throughout the federal judiciary. The Judicial Conference expanded its disclosure requirements for lower court judges, implemented new software systems to flag potential conflicts of interest, and established an independent review process for judicial financial statements. What began as questions about one justice's disclosures has evolved into a systematic re-examination of judicial ethics across the federal bench, observed Chief Judge Jeffrey Sutton of the Sixth Circuit Court of Appeals. That's a positive development for an institution whose authority depends on public trust. For Crockett, personally, the aftermath brought enhanced stature within Congress and the legal community. Having demonstrated both legal acumen and strategic restraint, she was appointed to chair a newly formed Judiciary Subcommittee on Judicial Ethics, with support from members of both parties. Representative Crockett earned this role through substance rather than spectacle, noted the ranking Republican on the committee. While we may disagree on many policy matters, her approach to institutional oversight has been principled and factual rather than partisan. Perhaps most significantly, Congress finally passed the Judicial Ethics and Transparency Act with strong bipartisan support. The legislation codified many of the reforms the court had voluntarily adopted while establishing new enforcement mechanisms and transparency requirements. The Crockett effect, as political scientists began calling it, demonstrated how factual, methodical oversight could bridge partisan divisions to address institutional concerns. Rather than approaching judicial ethics as a weapon to attack ideological opponents, Crockett had framed it as an institutional imperative that transcended partisan interests. Legal education also felt the impact of the hearing. Law schools across the country incorporated recordings of Crockett's questioning into courses on professional responsibility and judicial ethics, using her methodical presentation as a case study in effective oversight. What makes this hearing such a powerful teaching tool is how it demonstrates that accountability doesn't require partisanship, explained Yale law professor Stephen Carter. Crockett's focus on documented facts rather than political framing created a situation where the ethical principles at stake couldn't be dismissed as merely partisan concerns. 1 year after the hearing, its impact was acknowledged in an unexpected forum, the Supreme Court's annual financial disclosures. For the first time, these disclosures were published in a searchable online database rather than as cumbersome paper filings available only in person at the court. Each justice provided more comprehensive information about assets, speaking engagements, and potential conflicts than ever before. In a statement accompanying the new disclosure format, Chief Justice Roberts explicitly acknowledged the catalyst for these changes. Congressional oversight, particularly the thorough examination conducted by Representative Crockett and the House Judiciary Committee, helped us recognize the need for greater transparency in our disclosure practices. This acknowledgement, from the Chief Justice of the United States, represented a remarkable validation of Crockett's approach to oversight. By focusing on institutional integrity rather than partisan advantage, she had helped bring about reforms that decades of more politically charged criticism had failed to achieve. The most lasting legacy of the hearing may be its impact on how Americans think about judicial accountability. Prior to Crockett's methodical presentation, discussions of Supreme Court ethics often devolved immediately into partisan arguments about judicial philosophy. The hearing demonstrated that questions of disclosure, conflicts of interest, and recusal could be addressed as matters of institutional integrity rather than ideological preference. What Representative Crockett accomplished wasn't just exposing one justice's disclosure issues, observed constitutional scholar Lawrence Tribe. She changed how we talk about judicial ethics, demonstrating that accountability and independence aren't opposing values, but complementary requirements for a trusted judiciary. For ordinary Americans watching these developments, the Crockett-Kavanaugh confrontation offered something increasingly rare in public life, an example of oversight conducted not for partisan advantage, but for institutional improvement. The resulting reforms strengthened not just the Supreme Court's ethical framework, but public confidence in the institution itself, as Yale Law Dean Heather Gerken noted in a widely circulated essay. The most remarkable aspect of this episode is that it ultimately strengthened rather than weakened the court as an institution. By addressing legitimate ethical concerns through meaningful reform rather than partisan posturing, both Representative Crockett and the court itself demonstrated how accountability can enhance rather than undermine institutional legitimacy. This institutional strengthening may be the most important and enduring consequence of the day when a freshman congresswoman methodically presented evidence that a Supreme Court justice couldn't dismiss, changing not just one justice's disclosure practices, but the ethical framework of the nation's highest court. If you found this analysis of judicial ethics and congressional oversight informative, please like this video and subscribe to our channel. We bring you in-depth coverage of the pivotal moments reshaping American institutions with a focus on substance over spectacle. Thanks for watching.